Imagine this, your business partner stops working tomorrow, still wants half the company and half the profits. Hi, my name is Dustin Lee. I'm the founding attorney of Ascend Legal Solutions. We're a business law firm based out of Texas. Everything in this video is for educational and informational purposes only. We're not giving any securities advice, tax advice, legal advice, financial advice, or any other type of advice. If you need advice, contact a qualified professional in your jurisdiction. And nothing in this video creates an attorney-client privilege. In this video, you're going to learn the most common exit issues I see when a business partner wants out. If you stay to the end, you'll understand the 4 issues that can usually control the outcome: the right to leave, the buyout process, the control issue, and the valuation issue. What happens if the owners don't agree? For the purposes of this video, I'm going to use a Texas multi-member or multi-owner LLC as our example. The rules and the processes for other business entity types or different states can be a little bit different. Most of the time, they're going to follow the same sort of guidelines, but definitely want to look into the specific state laws and entity type that is relevant to your situation. And also, for the purposes of this video, when I say partner, I'm really talking about the owner of the LLC or the member of the LLC. Usually we're going to call them members, but most of the time, a lot of people commonly call them partners, like business partners. So when I say partner, what I'm really meaning is the member or owner of the LLC. We're going to cover 6 things. So first, we're going to cover that the operating agreement is probably more important than what one or the other owner really thinks is fair. Second, what a voluntary exit really looks like, whether someone is allowed to withdraw or must there be a buyout. And then also why leaving the business isn't necessarily the same thing as selling your ownership. Third thing is how owners usually fight over things like buyout price or valuation of the company, discounts, payment terms, company debt, especially if the company debt is owed to the owners. Fourth, we'll talk about what happens when the owners or the company reaches a 50-50 deadlock and is not able to move forward with anything. Fifth, we'll talk about the circumstances under which one partner can force the other partner out. And sixth, how you can structure the exit in ways that can potentially limit your exposure to risk for things like intellectual property issues, access issues, property turnover issues, guarantees, debts, you name it. When a business partner, like an owner of an LLC, wants out, the issue isn't really what they think is fair. It's what the parties agreed to going in. So the main document that you're looking at for LLC governing documents when you're talking about a buyout is the operating agreement or the company agreement. Now, the purpose of the company agreement is to set forth the rules on how things are going to work with the company, including voting of the members, voting of the managers. And for buyout specifically, it's going to be talking about things like whether there is a mandatory buyout, a voluntary buyout, right of first refusal, what happens on the death or incapacity of one of the members, what happens on the bankruptcy of a member, what happens on divorce, termination of employment, a number of things. It also critically can talk about buyout terms, about valuation, and about how a potential buyout or potential sale from one partner to the other would be structured. Now, Texas law gives the owners of a company pretty broad authority to agree to a lot of things in their company agreement or their operating agreement. And if they don't agree about those things, if they either don't have that sort of agreement, or if that agreement is silent or blank, maybe you only have a few page operating agreement, then you're going to have to fall back on standard Texas law. And unfortunately, a lot of times, standard Texas law, the default under the Business Organizations Code, a lot of times it's not going to fill in those gaps. So it's extremely important that you have a detailed agreement going into the business in the first place. Now, what people commonly refer to as a partner in a small business can actually mean a lot of different things to them operationally. Now, obviously, legally, it's got a very specific meaning. Partner or member has a very legally specific meaning. But in the day-to-day, in the business world, especially in small businesses where the owners are wearing a lot of hats and they're handling a lot of things, partner can mean just internally to them a lot of different things. So it's really first very important to draw that distinction on who is an owner versus not an owner, who is a manager versus not a manager, and then also what are the day-to-day roles, and are those roles as an employee or are those roles as an owner or as a manager? Now, the Texas default rule in a situation like this might actually surprise you. So let's say one partner is just completely fed up and wants out. The Texas default rule, unless it's changed in your operating agreement, is that you can't just unilaterally withdraw from your LLC. You can't just go in, hand in the keys one day and say, hey, I'm done. Doesn't work that way unless it's spelled out in your operating agreement. So just because you don't have an operating agreement doesn't necessarily mean that you don't have an agreement at all. There could be a written agreement or a verbal agreement that is between the owners that you didn't call an operating agreement that is actually supposed to deal with situations like this. The problem, in a lot of times in that situation where you've had a handshake deal or you've discussed it but never put it on paper, discussion may not be more around on what the deal is, but how can you prove what the deal is? And obviously, relying on scattered documents, trying to piecemeal together conversations or remember remember things years later is much less clean and efficient than having a document that's already set out to deal with situations like this. And I'll tell you, I have people come into my office all the time with either a DIY or AI operating agreement or no operating agreement at all. And they are surprised to find out things like, number one, the partner's not automatically just allowed to withdraw from the company. And then number two, if their partner starts working, they may still be on the hook for paying the partner all the profit distributions, even though they're not doing anything because it wasn't properly documented on the front end. And of course, that's very situational, but something that all owners should keep in mind that is a potential risk of not properly documenting. So short story here, a partner's exit can get really expensive when the partners realize that they didn't have proper documentation on the front end and they didn't really define what an exit is or how it's going to happen. Imagine this nightmare scenario, and we actually hear about it all the time. Partner comes in and says, I'm not working anymore, I'm done. But that doesn't automatically mean that they're bought out. It doesn't automatically mean that they are not entitled to their profits. And in fact, what they're going to try to do is collect their 50% profits from the entity, even though they're doing no work because the documents weren't properly done in the first place. It doesn't have to be necessarily nefarious like that, all right? So maybe one owner wants to retire, wants to take another job, wants to take a step back and just spend a little bit more time with family, whatever it may be. It's not always, a fraudulent situation or a situation where one owner is trying to take advantage of the other, but it does end up being an issue that can create problems with the business because the owner that is stepping back obviously is not providing as much value to the business anymore, but the ownership is not actually changing hands. So the best way to handle something like this, obviously, is to have a very thorough company agreement or operating agreement going in. But a lot of times, people don't have that. People either did it themselves or they just didn't have one at all. Or even if they hired an attorney to do it, maybe they told the attorney, hey, we just want something super basic. We don't want to spend a ton of attorney's fees coming up with every potential scenario where we may have to have an exit. We'll just handle it later on down the line. I'd encourage you not to do that. But from experience, I know a lot of business owners come in and that's exactly what they say. At a very minimum, I encourage folks to at least deal with death, incapacity, and divorce, and then the actual specific buyout terms for those. And taking a step further, how much work each person is allowed to or required to put in, or capital that each person is required to put in, and in situations to deal with at least those handful of things. So maybe if you can't think of everything, at least dealing with those handful is a good start. So there's a number of ways that you can handle the one partner or owner leaving. And even if it's not written up in your company agreement or operating agreement, you obviously can make an agreement later on when this situation actually arises. If it's not addressed in your company agreement or operating agreement, obviously in that situation, it's going to require the owners to be on more of a cordial footing. And if the owners are deadlocked or they're in a bad situation where they just cannot deal with one another, that's where these things can end up in court. So to structure the transaction, you've got a handful of options, and these options can actually be written into the operating agreement to start with if you prefer. The first option is company redemption or company purchase, where the company actually comes and purchases the owner that's leaving. It purchases their membership interest in the entity. Second is a cross purchase, where the other owner or owners purchase that interest. Third is a third party sale, where some third party comes in and purchases that interest. And a lot of times third parties, they're not going to be really interested in buying into a minority interest or even a deadlock interest. So it may be that if you're going to have to sell this minority interest or deadlock interest, you may have to sell 100% of the interest. In that case, you're going to have to get the other owner on board, or you're going to have drag along or tag along rights in situations like that. Next thing is an asset sale or a company sale. And this is a situation where essentially both owners are agreeing to liquidate all the assets of the company or to sell the company outright. Finally, we're talking about maybe a partial buyout, either by the company or the other owners, where the owner that is retiring or leaving continues to participate in more of a passive role, doesn't require them to do a lot of work, but they do get some smaller percentage of the profit share of the company that they've built. And obviously, each way that you structure one of these deals is a little bit different in how you're going to have to document it and how the different legal ramifications are going to play out. Now, if you do have a thorough operating agreement, you're going to have to check your operating agreement to see what the deal is with respect to the obligations that the owners and the entity are going to have to meet to get a transfer accomplished. What does that mean? There could be a right of first refusal for something like this. There could be a very specific valuation process that you have to go through. You may even have to get a unanimous approval from the other members of the company to accomplish. Finally, you need to consider whether the business or the other owners can actually fund the deal. So does the business have enough money to buy out the member that wants to leave, or does the other owner have the ability or the financial means to buy out the other member that wants to leave? Now, in a case of death, for example, the company or the other owners can actually carry life insurance for the other owners in the company. So for example, if owner A dies, then the company may have a life insurance policy that pays out the company to be able to do the buyout. or likewise, owner B may have a life insurance policy on owner A that pays out when owner dies, so that owner B has sufficient funding to buy out owner A when owner A dies. But with respect to any other types of transfers, you may not have the funding available, and you may have to get creative with the financing terms on how to actually accomplish the buyout. So as you can see, there's a lot of things that go into a clean partner exit, being the deal structure and the buyout terms, and then a number of other things that we'll talk about in just a minute. Most owners don't disagree that the exiting owner should get paid, but they do disagree about how much. So if you have a thorough operating agreement or company agreement, that agreement may actually dictate how the valuation is supposed to play out. I've seen really just as many different variations on this as you could possibly imagine in my practice. So I've seen some that just say, hey, we're going to do a book value valuation, and we're going to buy out based on book value. And then I've seen everything from there to much more complicated. Each party gets their own appraiser, and if the appraisers are within, a certain many percent, then you take halfway in between. And if they're more than a certain many percent apart, they independently hire a third appraiser to do a third appraisal. So as you can see, there can be really simple ways to do it and really complicated ways to do it. If you're not getting the appraisal and you're just sticking to some valuation method that's written down on paper without a professional appraisal, you have to be careful about how you do it, because a book value method may be good for a company that has a lot of physical assets, but it may not be good for, say, a service-based business that has no assets whatsoever and on a cash basis and keeps all their receivables collected at all times. So, in a situation like that, you may not have a lot of book value assets, and a book value valuation method may not be good for you. So if you are going to write in a particular valuation method into the operating agreement directly rather than having an appraiser, it's really super important to pick the right valuation method. In withdrawal situations rather than buyout situations, you may have to look to Texas law to see exactly what the course of action should be if your operating agreement doesn't address it. But again, if your operating agreement doesn't address withdrawal at all, the default rule is you can't just withdraw. It can be important to decide exactly when the valuation date is going to be. For example, if there's a particular debt that gets paid off just before, just or after the particular date, that may change things significantly. Likewise, big collection or big contract just before or just after a certain date may change things significantly. So it's important to decide on what date is the company actually getting value. Next thing is you may have a fight about discounts. So if someone is exiting and they don't have a controlling majority share of the company, then the one that's buying them out may argue for a discount to say, hey, nobody is going to want to buy this. Nobody wants to buy a minority share or a deadlock share of a company, and therefore there should be a discount on the valuation. Likewise, if there's company debt owed to the owners, that might also affect the valuation of what someone is willing to pay for it, either the company or the owners individually. Price and payment terms are different issues, so obviously you're going to have to not only work out the price, but also the payment terms. If the payment is getting paid in one lump sum, great. Usually it's not. Usually there's going to be some sort of payout over time, and the payment terms of the payout over time are also something that's going to need to be worked out. And then, of course, our favorite topic, taxes. Don't ignore the taxes. Talk to a CPA. Get the straight answer on the taxes while you're working through the transaction and not after it's over. The short story here, the business isn't just worth whatever number you pull out of a hat. It's worth what the documents say, what the valuation method says, what the appraisal says, and eventually what the parties are willing to agree. So what's one of the most common problems with multi-owner companies? I'll tell you this. The main reason that we want to be able to deal with all this stuff in the operating agreement going in is because if you don't and you end up in a deadlock, say a 50-50 deadlock, the entity can't take action, the management can't take action, and the entity is sort of just languishing and staying in the status quo and not able to either grow and move forward or even wind down, wind up because the partners are deadlocked. What happens then? Well, it probably ends up in court. A 50-50 company might work perfectly for you until the first decision in which you get deadlocked, you require unanimous consent, and now you can't. The owners could get deadlocked over literally anything. It depends on how much authority one person needs to complete a transaction without the other person. But on all major business decisions, you can probably expect that a deadlock may be in the works. So, for example, whether or not to pay out distributions versus retain that money to grow and expand, whether to hire a key employee that's going to cost a lot of money, whether to enter into a big contract or transaction. Things like that are the most common issues that you see where the owners will start to deadlock. Another big one is when the business is strapped for cash and the owners have a dispute about which debts to pay and which debts not to pay. In terms of a buyout, a deadlock can sometimes mean that your operating agreement is not dealt with exactly what the terms of a buyout should be. a valuation method, an appraisal, or anything like that. Some agreements get a little creative with it and do like a Texas shootout or shotgun type of method, they call it, where one owner names a price and then the other owner gets to either accept that price and buy for that price, or can turn around and sell for that price. So if you are the person making the offer, it's incentivized you to make a fair offer, because if you don't make a fair offer, you could end up on the losing end of that deal. As you can imagine, provision like that does tend to move things along faster, but it also can end up to favor the person with the more cash. So for example, if you make an unfair offer, knowing that the other side doesn't have the cash to buy you out, that could be prohibitive to the other side. And that's a situation where maybe a shotgun type of deal is not really that fair. Next thing is, how do you keep your business running during the fight, especially if you're deadlocked? You may be stuck with decisions that need to be made. And if you can't work that out, again, this is sometimes where it ends up in court. Now, Texas law does provide a procedure for when the entity is deadlocked, that there's a way to go through the judicial process to wind up the entity. But I'll tell you right now, with both sides getting a lawyer, or maybe even the company needing a lawyer, honestly can eat up a lot of the value of the business, because you're spending a ton of money on attorney's fees to get the entity wound up. Another alternative is receivership, where the court appoints a receiver, someone that is usually a lawyer but doesn't have to be, experienced in running businesses, to actually take over and operate the business, try to rehabilitate the business while the owners work out their deadlock in court or outside of. In a situation like that, the receiver can actually do a great job running the business, but the receiver is getting paid from the business. And if the receiver is getting paid from the business and both of the owners are hiring attorneys to fight out the deadlock, again, it sucks all the value out of the business, and it's really not a situation you want to be in if you can help. So the business reality here is sometimes a receiver or court intervention is required, because you absolutely cannot get the issue handled on your own. If at all possible, you want to try to avoid that by either making an agreement with the other owner at the time the dispute arises, or ideally a process to deal with that when you actually sign the operating agreement when you first start. Deadlock doesn't really just stop the owners from agreeing. It can actually stop the company from functioning while the value just constantly disappears and there's nothing left to fight over. Just because you fire your partner on Monday doesn't mean he's not going to be entitled to distribution on Friday. What does that mean? Well, that means that typically ownership doesn't just disappear for poor performance. Let's say an owner stopped working, an owner just fails to meet their duties, fails to hit certain key performance indicators, or maybe they're just not doing anything at all. A situation like that, just because they're not doing those things doesn't mean that they have to give up their ownership interest unless you've actually got an agreement for that. Sweat equity works great, but it can be a risk if you don't have it properly documented. Next thing, removal of a manager in a manager-managed LLC is different than removing a member. So let's say you do, for some reason, have the voting authority to remove a manager, and because you are the majority owner of the LLC, let's say you remove the other owner as a manager. Okay, well, now you've removed their management rights, and you've removed maybe some of their big picture decision-making authority, but you have not removed them as an owner, and you've not removed their ability for them to collect their distributions when profits come around. Forced buyouts, where you're actually forcing your other business owner or business partner out. They're going to have some contractual authority. You're going to have to write it up in the operating agreement. So a strong agreement on something like this is going to be very specific about what the criteria is to eject someone. Now, that may mean only the really big issues like fraud, embezzlement, breach of fiduciary duty, something like that. But it could be, that some people actually like to build in key performance indicators into their operating agreement, to where if one of the partners is consistently not hitting their KPIs, then there's a potential for ejection. Now, that cuts both ways, because if you're not hitting your KPIs, your partner could kick you out. But likewise, you may have the ability to kick them out. So it's a dangerous situation to have it in there and be non-specific. It's also a dangerous situation to have it in there at all if you think that maybe you're not going to be able to hit your key performance indicators as well. But you can really customize it to meet your needs. And if your needs are for the KPIs, then you can certainly build that in. What you will want to avoid entirely is just really vague nonsense terms like bad behavior or failure to contribute. Things like that are probably not going to get you anywhere. Be careful with forcing a significant discount on the person that you're forcing out. If you force a significant discount, it's going to be significantly more likely that this thing ends up in court. So a little bit safer way to do it is to only give a slight discount or no discount at all, even though they're being forced out, just because it's much more likely they're going to fight with you. Again, it's up to you. If you want to take that risk, or if you think that having that punitive measure in place will help your partner perform, great. But, if that's a situation you're in going into this thing, maybe it's not the best partner for you in the first place. Additional thoughts, and this just goes for business in general. Always follow the process, always follow the procedure that's written out, always follow the contract that's been written up. Obviously, if you have questions about it, seek the advice of an attorney, but you need to follow the process that's written out in your company agreement or operating agreement. You do probably have the ability, if the parties are cordial, to work out a different agreement if everyone's on board. Likewise, in these bad behavior scenarios, the company may also have a claim against the bad behaving owner. So if the owner stole money from the company, if the owner committed fraud on the company's name, something along those lines, the company may actually have the ability to go after and pursue claims against the bad behavior. Short story on this one is you can remove your partner's title much easier than you can remove their ownership. Without a forced buyout scenario written into your operating agreement, again, you may be stuck in court on this one. A side buyout agreement doesn't help much if the former partner still controls the bank account, owns the domain, and guarantees the lease, along with everything else in the business. So all these things need to be properly documented in your buyout agreement, or you risk having issues later on. So goal number one for something like this is to properly document the transfer, not only of the ownership interest in the company, but also of any assets, accounts, etc., that the exiting owner controls. Part two, removing the operational authority from the exiting owner. So making sure that the exiting owner can't just turn around and empty the company's bank account the next day. Obviously, you're wanting to notify vendors, customers, employees, banking relationships, and things like that to make sure that everyone is on the same page as far as the exiting owner's lack of authority in the future. Now, a transfer of ownership in the business doesn't necessarily extinguish liabilities of the business or personal liabilities of the owner associated with the business. So in this case, we're thinking about personal guarantees for like lines of credit or leases. And an agreement between the owners or the company to handle those sorts of things doesn't actually extinguish the exiting owner's obligations if they sign something like that, like a personal guarantee. It may actually be a breach of your contract with the landlord or with the lender to change the ownership of this entity without their permission. Obviously, one of the big things that you're dealing with in a buyout scenario, non-solicitation, non-competition, non-disclosure, confidentiality, intellectual property, all of these things need to be handled in the agreement, or you risk the exiting owner just turning around and starting the same business with the same people, the same information, the same customers, and taking all the value with them. So what are we really talking about here is that the exit needs to be a clean break, and all of these different things like authority, money, access, guarantees, future obligations, all need to be handled in the agreement, or you have risk that something goes wrong after the agreement is signed. Usually the operating agreement is the agreement that is going to be governing this situation with the buyout, and you may have to fall back on Texas law if you don't have an operating agreement, or if your operating agreement is silent about the buyout terms. Second, either leaving or removing someone from the day-to-day management authority of the business does not mean that they have been ejected as an owner, and it does not mean that they're not entitled to their profit share. Third, valuation disputes aren't just about a number that you picked out of your head. There are a number of different valuation methods, as well as appraisal procedures that you can go to and you can build into the operating agreement or into the agreement that's happening later on down the line. But I would say, be careful about just grabbing a number out of your head and saying that's the number that's on the table. Fourth, a 50-50 deadlock. We talked about how that can actually freeze up the company, have the company and the owners end up in court in either a forced wind down situation or a receivership, both of which are just going to drain the value out of the business. Fifth, we talked about forced buyouts and what the situation is with respect to those and potentially some ways to view or approach them, or at least think about them when you're looking at a situation like that. And six, a number of things, obviously not all the things, that you need to think about that may be issues post-transaction, such as transfer of ownership or control of accounts, of assets, and then what happens with personal guarantees, leases, things like that. If you want to learn more, go ahead and visit our website, ascendlegalsolutions.com. This video is for general informational purposes only. It's not legal advice. No attorney-client relationship is formed by this video. Thanks, y'all.